is ill and would not be able to make it for the proceedings.
Thank you, member. All right, we will move on to confirmation of the minutes of the meeting held on Thursday, September 14, 2023. Starting with page 1. So members, there's a technical problem printing, but they'll be coming down. Would you like us to defer? All right, so we will defer the minutes, and when we get the actual printout, we can. So members, our legal counsel advised that there are some matters arising from the minutes that would need to be addressed, so we can't simply defer. That we just deferred, but Mr. Nash went to check on the physical copy, so we'll give him a few minutes. Because you were saying there are some matters that we have to agree on, yeah. For those members online, we're just waiting a couple of minutes for a printed document to circulate in Parliament. Printed copy of the minutes. All right, so everyone should now have a printed copy of the minutes, and we will start again. We'll recommit the minutes starting from page 1. All right, on page 1, there's a correction to update the title for Mrs. Anastasia Gordon-Jones. On page 2, under matters discussed, second paragraph, in the middle of it, where it begins, she said that with the current system, it was seen that decisions were not made timely, made on a timely basis. And then in the next sentence below, she explained that matters with language given there was an act which stipulated a time frame for decisions to be made, whereafter, that should be one word, right? The matter would fall away. Well, the point there, right, if the time frame for the decision, if the decision was not made within the time frame, the matter, legal counsel, what's the correct word? It would lapse and nothing would come of it, is the point I was trying to make there. It would lapse. All right, so that was page 2. Page 3. Second, third, third paragraph. The last sentence that begins, he said that the recommendation from the PBCJ would go to the highest authority, which was the council, who would then make this decision, would then make, right? Instead of made, we make. And then the paragraph below that, to the second to last sentence that starts, he explained that the problem with the PBCJ making decision was that it would be the instrument held accountable to the decision made. Is that correct? Page 3, and it is the paragraph that begins with Senator Gale. If you go down to the second to last sentence in the paragraph beginning, Senator Gale explained. Just when I read that first, it didn't sound grammatically correct. He explained that the problem with the PBCJ making this decision was that it would be the instrument held accountable to the decision made. Right, yeah. Oh, you did say instrument? You did say instrument? Well, we'll go to the recording. Okay, that it would be the body held accountable to the decision made or for the decision? All right, we'll move on to page 4. In the body of the second paragraph, I'm just questioning that sentence. She stated that there was only one decision maker who was the council. Is that correct? Because I thought the PPC, huh? Mrs. Aldred. Yeah.
I think based on what solicitor was saying at the time, was in relation to a scenario where the council would be the decision maker. So she was speaking in relation to that scenario. So it would be correct.
So we move on to page 5. Page 6. At the bottom of page 6, oh, sorry.
Good afternoon, Chair and members, colleagues. In relation to page 6, the second to last paragraph.
Oh, no, wait.
I'm seeing where the committee agreed to remove the subparagraph 1C and include a senior educational administrator. We're seeking clarification as to whether it should be administrator or professional, because maybe the term administrator might be a little, it's not as wide. It might be a closed group based on the term.
Chair, Mrs. Gordon-Jones is correct, because a senior educational administrator could be a single category or role in an organization. And what we're trying to capture is the profession or the professional scope of the person. So it ought to be a senior educational professional.
All right, so member, we have to take that in matter arising, because the minutes captured what was actually said, and then, right, okay.
Sometimes that happens.
So matters arising, if you could bring that up, yes. In the last
Chair?
paragraph on page 6.
Chair?
Oh, Mr. Foreman, please go ahead.
Right. Yes, my apologies. On page 5, in the last paragraph, the sentence that reads, Mr. Foreman highlighted the issue was because a recommendation was made to include provisions to ensure and so on. I would recommend deleting the words after ensure and add the words decisions of the PPCC appealed to the appeal tribunal. Because the context of it wasn't the PPCC dealing with any decisions made by the council. The PPCC doesn't have any of those responsibilities.
I'm sorry, Mr. Foreman, could you repeat for us, please?
Right. I'm recommending that after the word ensure, the language reads decisions of the PPCC could be appealed to the appeal, and delete what is there, just for accuracy. I can share the language with Mr. Nash.
All right, Mr. Foreman, are you trying to amend what is here in the minutes?
Yes, I'm suggesting a different formulation of words that would better reflect.
Right, okay, can we take
It's not what was said,
matters arising then?
Okay, very good.
Pardon?
That's fine.
All right, good, thanks. Paragraph, the highlighted sentence, the highlighted last sentence, the committee agreed that the PPCC with the revised makeup would be the body to interrogate the situation of the disciplinary matter, refer to it, and make a decision in writing. All right, we'll move on to page 7. Oh, Ms. Gordon-Jones.
Thank you, Chair. A correction to the first sentence. Mrs. Gordon-Jones indicated that clause 83 was renumbered as clause 82 because clause 82 was deleted as it contained repetitive content found in clause 81. That should be 80 subclause 1, not 81.
All right, thank you. Any other corrections on page 7? None. We'll move on to page 8. Page 9. Page 10. Page 11. All right, may we get confirmation for the minutes? So moved by Member Hamilton, seconded by Member Gale. All right, we move on to matters arising. Ms. Gordon-Jones.
Yes, Chair, we'll revisit the matter of the term administrator as against professional. Senator Gale was making a comment on that.
Page 6. So we'll amend that to educational professional. All right, agreed, all agreed on that amendment? All right. Yes, sir.
I thought it would have been green when I can talk, but anyhow. The reference to senior educational professional, if Mrs. Gordon-Jones could just remind us, where is it in the schedule? What part of the schedule it is dealt with? I'm a little concerned that it is ambiguous. So I have to stop. That is it? Oh, okay. All right, so what I do? Oh, okay.
Thank you, Chair. It's at Part B, paragraph 1. It's on the document that starts with clause 51. So it's the first schedule, Part B, which treats with the Professional Practice and Conduct Committee. Paragraph 1. So C was changed to that category. But just to, in terms of the category, Chair, I remember there was the discussion of saying a retired senior educational professional. Right.
It actually. That was one of the thoughts I had. A senior educational professional, would that mean that is somebody who is active? That's one. And who is exactly a senior educational professional? Do you have to have a master's? I don't like the phrase. It's going to lead to quarrels as to who is a senior educational professional. We have to find something that is more. A senior teacher, people understand that. A teacher, a retired senior teacher, somebody in the profession for more than 10 years.
I think they were referring to the master teacher, right? I think the idea was to utilize the master teacher. So, and I think at the last meeting I said, why not just use the term master teacher?
But then that's a designation, and the persons, there are not a lot of people with that designation. So
yeah, but that's what they want.
The question to me is better to say somebody that has a particular requisite experience, or somebody who has been a principal, something that is more certain. My basic school teacher is a senior professional. She has been doing it for 50 years. Is she eligible? These are things that may arise. So I would prefer a more definitive terminology. I don't know what you think.
All right, let's hear from Dr. Gordon. I understand she would love to make an intervention.
Thank you, Chair. Good afternoon, everyone. We had there a master teacher because that is the only person who would be very well prepared to hear any matter that concerns the practice of the profession. And I really think we have enough master teachers. At the moment, with the ones recently approved, we have over 80 master teachers. That would be enough. We only need one person. And the master teachers are from all the quality education circles across Jamaica, the 63 quality education circles. By the final approval of master teachers, we should have about 80. We should shorten.
Chair, I recall the discussion, and this may have been why in the first instance you had the word administrator, because it could have been someone who is in the profession, in the industry, but not necessarily a teacher, but a senior administrator. A principal, or anybody somebody who works in the Ministry of Education, but someone who has been in the profession. That's where I thought we had taken the discussion, why it extended to someone senior, defining experience, not necessarily qualification, as Member Braham may have suggested, but someone who is experienced in the profession.
A master teacher is somebody who is experienced in the profession.
We're not saying that, what Dr. Gordon, the master teacher, it just makes it specific to a teacher. But we are expanding this particular position to someone who was experienced in the industry.
Chairman.
Well, I remember, I think what Member Braham was trying to say, that we needed to bring greater specificity to that particular phrase because it may cause problems down the road. And so we could say, members of the executive management team at the ministry, or whatever it is that we decide on, we have to be more specific about it.
Chairman, I think whatever the definition we use, even if we keep the senior professional, we should include persons who are either a teacher. When I say a teacher, I am a little concerned about persons who are still practicing. But if we choose to keep those who are still employed in the system as a member, we should also give the option to use a former teacher or a former person then, a former senior professional, somebody who has moved on to work at the bank, but they're taught for 20 years or they were leading for 20 years, or a retired person. They should be included to widen the pool that you can choose from. I would have preferred to use either experience, somebody who has been a teacher teaching for 10 years, 15 years. That's one way of dealing with it. You can find that type of person, or a former administrator, I don't know. But if the committee is happy with senior professional, I suppose the court will grapple with what it means.
No, but I think we can define it. We should define it.
Chairman, currency of practice is very important in these kinds of discussions. It's good to have retired people, and we do have scope for that in that same committee. But currency of practice is important. And our master teachers are well-experienced teachers. They could be principals. In fact, they manage professional development. They're an integral part to the quality of practice of the profession.
But could we say then, if we use that word, to include master teachers, professionals, retired persons? No? You have to define it.
Yes, Minister.
Guys, we really need to get past this one.
I agree, Minister.
Mr. Gordon-Jones, how would we define it to also include master teachers in it?
I would think that, Chair, we would have to speak to the years of experience in order to capture that.
All right, thank you. Could we say someone who has at least 15 years of experience in the teaching profession or in the education sector?
they
Remember the last occasion we were here, the discussion started around principles because we wanted somebody who is aware of, the running of the school, the operations, administration, and that is why the discussion led to where we are now. But to broaden it to include anybody in the sector, I think defeats the purpose of why we had that person there in the first place. So I don't have a difficulty with the use of the term administrator, but now we probably need to define years of experience and every other qualification that we need to put in, 15 years, whatever it is. But I think the administrator aspect of it is what we need to capture.
Remember, administrator in the public service is very different from the principal. The principal is not classified in the service as an administrator. The principal is classified as a principal. So if we're talking about principals, we have to say principals. And just...
Chair, I think we maybe can say a retired principal because we have many retired principals that we could use.
Is that acceptable to committee members?
So the retired, I am not saying you should limit it to retired principals. I'm saying that you should have that category in there as well. So if you can find a current principal that you think is suitable, that's fine. But I assure you, when you think you have plenty of people and you can't find them because they refuse to serve, or when you check different people, they say, this person, I know him. I have known him and because he's so popular, and it is difficult to find somebody, it would be unwise to limit yourself to current serving people. I'm not ruling them out, but I would add the retired as well, so you have a wider pool.
All right, so Ms. Gordon-Jones, why can't we give a categorization for senior educational administrator, which could be principals, retired or current, education officers. We can define it that way, can't we? Miss? Yeah, okay.
Chair, I was just discussing with the drafter. We can define the senior educational, is it professional or administrator?
Professional. Yes.
And so would we retain retired? Retired. Okay, so we can create a definition with a list of persons. Includes.
All right, so we agree that that phrase will have a definition to it. Are we agree, members? Okay. Yes?
Just want to agree with, seek clarification on the agreement. Are we defining retired senior educational administrator, or we are saying it include retired persons?
Includes, yeah. No, includes.
Thank you.
Yeah. All right, are there any other matters arising?
Yes, Chair. On page 9, the first paragraph, which treats with the matter of the appointment of the members of the Professional Practice and Conduct Committee and the chairman. I need clarification on that in order to issue drafting instructions. The minutes, it's currently indicating that, page 9 of the minutes, yes, that this would be Member Hamilton. Says she put to the committee for the council, it's the chair. She put to the committee for the council to choose the members of the PPCC, who would then choose a chairman from amongst their membership. It was put, but I'm not seeing where it was accepted, so I just need a clarification as to the decision in terms of the appointment of the members. Currently, the draft has the members are to be appointed by the now changed to council with the approval of the minister. So the approval of the minister is to be removed. It's just the council will select the the members of the PPCC.
That was my understanding as well. Right? The minister would select the council at the council level, but not at the PPC level.
Chair, I think we had agreed that for the PPCC, the council would choose the members and the chairman, or the council would choose the members and the chairman.
So I'm seeing here, Chair, where they on my notes I have that they choose among themselves the chairman. And I'm also seeing something similar to that in the minutes. It was put, but it was not agreed on. So it says she put it to the committee for the council to choose the members of the PPCC, who would then choose a chairman from amongst their membership.
I think that's what we said. Yeah.
It was not
It was not recorded that we agreed, so we would need to do so. So I put it to the committee members that the council would choose the members of the PPCC and that the PPCC would choose a chairman from among them. All, okay. The committee members agree.
Thank you.
Please continue, Ms. Gordon-Jones, if you have any other matters arising.
In relation to temporary appointments for the chairman, it's on the same page, page 9. Chair noted that there is no provision for temporary appointments of the other members. It was only in relation to a chairman. In the absence of a member, there is no provision to treat with the temporary appointment of another member.
Chair, the discussion the last time, I recall querying what this absence or inability to act would look like in terms of time period. And I think that is probably one of the things that we had asked to review, because what is a temporary appointment? How long does that last? Is it 6 months? Is it 3 months? Are we saying that after the chairman becomes unable to act after 6 months, or a member? So we may have to make it general rather than speak to just the chairman of the committee. So if it is general, then it can capture everybody, but we still need to put some timeline, some specific time period in it to say after 2 meetings or 3 meetings, then, you know, this temporary appointment can take place. And how long will the temporary appointment last? So we have to factor those in.
Chair, SG had provided guidance in that regard. She referred us to Section 18 of MOCA, the Major Organized Crime and Anti-Corruption Agency Act 2018. Section 18, if it's three subsections under that provision. I can read, if you, with your permission, Chair, what it states. It says, where a vacancy arises in the office of the Director General, a suitable person may be appointed to act in the same manner in which an appointment is made under Section 12 until the vacancy is filled. 18.2 says, where by reason of illness, absence from Jamaica, or other sufficient cause, the Director General is unable to perform his functions under this Act, he may, after consultation with the committee, appoint an officer of the agency to perform these functions for a period not exceeding 2 months. 3, pursuant to subsection 2, if the Director General is unable or fails to appoint a person under subsection 2, or it is necessary to make such an appointment for a period in excess of 2 months, the appointment shall be made in the same manner as specified in Section 12. So SG had indicated that we could use a similar format as stated in this Act to treat with temporary appointments.
In that situation, you would have a position that there is continuous activity. So that Director General would be in place and expected to perform duties consistently. In this case, it may be, once we define a period, there might be no activity within that period. And so we'd have to determine if the absence is in relation to meetings or an event or occasions. So we'd have to align it that way, because there may be that this period of indefinite activity. Yeah.
Please go ahead, SG.
Thank you, Chair, and good afternoon to you and members of the committee and colleagues. Just to clarify, when I pointed out that provision, it was that I was suggesting that that is the way to go. It's just that it was just showing that there are examples in law where you will put timelines in terms of when someone is acting temporarily. And of course, it has to be tailored to the specific situation you're looking at. The Teaching Council bill doesn't have to have something as elaborate as what's in MOCA. You already, if you're going to put in a temporary, allow someone to be appointed temporarily, it can be a very simple provision and you just put a timeline in it. It really can be one sentence. Thank you.
I'm sorry, Member Hamilton, you wanted to make an intervention?
No, Chair, I was just agreeing with the SG, saying it's really the timeline that's important where I'm concerned.
Okay. Given what Member Gale said, that there may not be meetings because there are no agenda items, then it would be in the number of meetings. Yeah. So to our legal counsel, you got that?
Thank you, Chair. Yes, the intention was not to use the exact wording, but we know it was to be used as some sort of guidance to treat with the provision. The next matter arising is in relation to revocation of appointment. Same page 9 of the minutes. I recall SG made a suggestion for us to use the wording from the NERA as a guide to treat with this provision, and then we could retain some of what is currently listed to reformulate the provision. So under the NERA, the provision reads, Chair, can I read what the provision would be if we are to use the guidance from the NERA? Sorry? So the provision from NERA is it's the paragraph 3.1 of the first schedule of that act. It states that the Governor General may revoke the appointment of a member of the authority if the member A is suffering from a mental disorder or is defined in the Mental Health Act, or if the member is by reason of ill health permanently unable to discharge any function as a member. B is or becomes ineligible to be appointed as a member, or C engages in any activity that can reasonably be considered prejudicial to the interests of the authority. So currently paragraph 6A says becomes of unsound mind or becomes permanently unable to perform his or her functions by reason of ill health, whilst the NERA speaks to the Mental Health Act, and that's what we also see in other legislation, that wording. Right. So based on those provisions on the NERA, we would use 3.1A to C, as was previously read, and we would also retain from the current draft B, C, B, C, E, which should be D, which should be read as E, F, and G. And Chair, there's a draft. I could read it to see if it's suitable for the committee.
Maybe I should listen to it because my concerns may be captured.
Revocation of appointment. 6. The council may at any time revoke the appointment of the chairman or any other member of the committee if the chairman or that member, A, is suffering from a mental disorder as defined in the Mental Health Act, or if the member is by reason of ill health permanently unable to discharge any function as a member. B, is or becomes ineligible to be appointed as a member. C, engages in any activity that can reasonably be considered prejudicial to the interests of the committee. D, is convicted of any offense involving fraud, dishonesty, or moral turpitude. E, becomes bankrupt within the meaning of the Insolvency Act. F, fails to attend 3 consecutive meetings of the committee without the leave of the chairman. G, fails to carry out the functions of his office as specified by or under this act. Or H, is sentenced to a term of imprisonment. Yes, based on SG's guidance.
There are 2 points. One is probably more substantial than the other, so they're probably the least substantial. In terms of sickness, permanently become sick, my word. But then you can become sick for a substantial period of time as well. The permanence and the determination, whether it is permanent or not, I wonder if you also included a substantial period, if that would help. I'm not pushing it, but I wonder. But more importantly, though, do you have the right to remove somebody for inefficiency? Under the education code, people can be disciplined for inefficiency. So what happens if I'm a member who behave as I do and attend the meetings irregular and so on and so forth? But I might come to 2 meetings, but I don't do the work. I'm inefficient. Should that be a basis for removing somebody?
Yes, because in current boards, I've seen where we've had to remove board members because they just did not show up for meetings. And if they showed up, they didn't necessarily participate. Yeah.
Recall that this is not the board, this is the PPCC.
But we do need active members of the PPCC. We don't need any dead weights on that council.
So we'll include non-performance then, Chair. I think it is definitely necessary under the circumstances.
Agreed, member.
Other question in relation to this, because I know we're referring to the revocation, but are we now going to try to, the disqualification of appointment? I think they have to. So if we recall, under the disqualification of appointment, it said, yeah, you can be a member of the Senate, the House of Representatives, member of the Council, be convicted of an offense involving fraud, dishonesty, moral turpitude, or bankrupt. It doesn't state anything about somebody being convicted of any other offense, which I would interpret to mean that if somebody has been convicted, then they can be a qualified person under the circumstances. Of anything.
But they are morally turpitude.
No, what's... It's not there. There's nothing there disqualifying anybody who has been sentenced for any term of imprisonment.
But they wouldn't put them on the council.
No, they're not on the council. It's PPCC. Yes. So remember that the PPCC is not the council itself. The PPCC is a separate set of individuals that the council would appoint to act. But the council would be guided by this document to determine who can be qualified, and if we don't include from the beginning that somebody who has been sentenced to a term of imprisonment is not qualified, then they would think that somebody, you know, having that particular, it is in your draft, but we don't have it. All right, so Chair, it would appear as though Mrs. Gordon-Jones has addressed it, and we'll await her draft.
All right, thank you, Member. Ms. Gordon-Jones, you just want to read what you have, the draft that you have.
A person shall not be qualified for appointment as a member of the committee if the person A is a member of the Senate or the House of Representatives, B is a member of the Council of the Kingston and St. Andrew Municipal Corporation, City Municipality or Town Municipality, C has been convicted of an offense involving fraud, dishonesty, or moral turpitude, D has been sentenced to a term of imprisonment or to death, E is bankrupt within the meaning of the Insolvency Act. So the sentence, the matter of sentence was inserted.
Do you need to be on microphone for that comment? Okay. All right. Is there any other disqualification points that we need to include in this? Just a question. What if somebody's what if somebody's a sex offender? Would that get caught? Would that be?
Yeah, but how are sex offenders identified?
They must have been convicted.
Huh?
They would have been convicted.
They would have to be convicted.
Mm-hmm.
Right. So they would have to go through the system. And right, and Mr. Braham here is mentioning the moral turpitude aspect of it.
All right, thank you, members. So we are accepting, is that clause 5?
5 and 6.
5 and
I just
6.
did clause 5 and 6.
As read.
Disqualification or revocation.
Members? Okay. Ms. Gordon-Jones, could you send a copy to
We shall.
Mr. Nash? Yes.
We shall.
So please carry on.
The other matter arising is in relation to the penultimate paragraph, the last sentence that is highlighted. It says the committee. Yes, same. I have two more matters on that same page. So the committee accepted the suggestion to amend paragraph 7 to replace the words from the date of receipt to on receipt. I'm on page 9. In terms of that, Chair, I recall SG suggesting that we use the language from the Constitution. We could use it as guidance in crafting that provision, section 137(2). And as a result of that, we did a draft of the provision. Chair, with your permission, can I read? So clause 7, paragraph 7, resignation, 7.1, any member of the committee other than the chairman of the committee may at any time resign his or her office by notice in writing to the chairman of the committee, and the resignation shall take effect when such notice is received by the chairman of the committee or any person authorized by the chairman to receive it. 2, the chairman of the committee may at any time resign his or her office by notice in writing addressed to the chairman of the council, and the resignation shall take effect when such notice is received by the chairman of the council or any person authorized by the chairman to receive it.
That sounds a little odd to me, though. Because if I resign and I send in a letter as chairman to the council, and the council said I never received my letter, what do I do? All right. Okay. All right, so committee members agree with that? Mrs. Gordon-Jones? Yes.
And the last matter arising based on the minutes is in relation to paragraph 8. I recall SG indicating that we could use paragraph 4 of the first schedule of NERA as a guidance to treat with this paragraph. And based on the suggestion, we looked at the provision, and the draft that is proposed is a vacancy in the membership of the committee shall be filled in the same manner and subject to the same requirements as applied to an original appointment of a member.
I agree with that provision. It's the most succinct I've heard in a long time. No.
I thought I heard you say that that is perfect. All right, carry on, Ms. Gordon-Jones.
Chair, the other matters arising from the minutes would have been in relation to the suggestions made by SG in using some provisions in other legislation, for example, in relation to disclosure. I am not sure if the committee wants me to read what the provision would read. So in relation to the draft, voting 11.2 and 3, it was agreed that voting should be a separate paragraph, and 2 and 3 be treated with as the disclosure aspect, and also for the inclusion of the protection of members. So I'm not sure, Chair, if you want me to read what.
Yes, please.
Very well. So the disclosure provision would based on the insertion of the matter of the committee being able to make its own rules and them being gazetted, that disclosure provision would be paragraph 13, and it would read, a member of the committee who is directly or indirectly interested in any matter being considered by the committee, A, shall, as soon as possible after that fact comes to the attention of the member, disclose, either in person or by notice in writing, at a meeting of the committee, the nature of the interest, and B, shall not be present during the deliberations or take part in the decision of the committee in respect of the matter. 13.2. The disclosure of interest by a member pursuant to this paragraph shall be recorded in the minutes of the meeting at which the disclosure is made. That would end the paragraph 13.
Oh, okay. That's what I wanted to clarify.
Okay, so
this
we
deals
have
with 12.
inserted the matter of rules as paragraph 11. By rules, so we have remuneration at 10, and then we add rules at 11. Rules. Says the committee shall make rules setting out the proceedings for an inquiry, and such rules shall be published in the Gazette.
The original 11 spoke to voting, and within the ambit of voting, there would have been a declaration. But the provision you just read, perfectly and succinct, was around more expansive, a declaration. In other words, declaring interest in a matter and not specific to voting.
Right.
So are we now inserting a different provision that speaks to declaration, separate and apart from disclosure? Okay, generally.
So it would be now, rules is 11, voting is 12, and this disclosure is 13.
13. So, but the disclosure, the general disclosure, would cover particular voting situations. So you would have to disclose at the onset, as long as you've identified that you have any kind of association. You are a little bit more specific.
Because voting is an activity solely on its own and should be treated separately. I place more emphasis on disclosure, and I believe disclosure should come higher up in the sequence of provisions. Move it. No, I'm saying that now. That's why I said bear with me, because I'm taking it through. Yeah. But then you would have in voting the possibility that you would have to declare interest around the aspect to which you are voting. No, because...
So why won't you declare it upfront?
Treat them differently. Suppose, for argument's sake, you are hearing a matter, and the matter involves someone directly related to you. That's a disclosure. But in voting now, voting is voting on a particular matter separate and apart. So I want to treat them...
You still have the duty to disclose.
Yes.
So I don't appreciate how it is that you would get to a voting stage and then have to declare when you should have declared from the beginning.
No, but you are voting on a particular matter that may never have existed before.
Yeah, but the declaration would still cover it. The general declaration is right. It's continuous.
Okay, I hear.
And then, based on what was read by Mrs. Gordon-Jones, it would also cover the fact that you can't vote.
Yes, man, and I understand that you'd have to recuse yourself in that situation, having made the disclosure. I just want to see, my preference is to see how it flows in terms of the provisions.
So Chair, I think I had a eureka moment when Senator Gill was trying to have the disclosure provision above the voting provision. I think that is, yeah, that was I didn't realize that that is what he was trying to. I don't have a difficulty with moving the disclosure up because I really do think it would make sense and it would flow better. So I do agree, Senator Gill, that you have a point. A eureka moment, yes.
So, Chair, we would put disclosure before the voting provision.
So put it after the rules.
Right.
So, Chairman,
Graham,
I'm sorry that I am, but anyhow, the question of these rules now bother me. I don't know, have we considered the process of getting these rules made?
It was discussed last week at the last
It's a very
meeting.
involved process, you know. And to get them gazetted and so forth.
They would have to do that at the beginning.
Do we need... No, they're not going to form part of a schedule. This is the rules that the committee will make. But there are many court challenges and many authorities, so to speak, are required to have rules, and they are existing forever and never pass any, and people go to court. Lots of lawyers who come out in the newspaper challenge it and use it against them.
So how would you operate, though? I mean, the committee has to have some rules.
Yeah, but the question is whether the rules, all rules require publication in the Gazette. No, but I don't finish yet. You can answer.
Oh, I'm sorry. I was thinking ahead of you.
Yes, you recollect.
Because you weren't here last time.
The question, do we, if you have rules of procedure and you publish it and make it available to the public, that's fine. But to go to the next stage and get it in the Gazette and so on, it's time consuming, it opens the challenge if it is not done, if it is forgotten. I'm just asking, and if you have considered it already, then we can move on. Is it really necessary to gazette the rules if it is simply published on their website and made available to whoever wants it when the time comes?
Maybe we can ask the SG.
All right. SG, you had given us an opinion the last time. Can you give us further guidance? Or SG? SG, you had given us some guidance about whether or not these rules should be gazetted.
Yes, I apologize for the delay. Just had a technical issue with my forefinger and the computer. No, the rules don't have to be gazetted. They could be published on our website. Just that, judicial notices taken of documents that are gazetted, a la the Jamaica Gazette Act. But they can be published. The big issue is to make sure that the public can access the documents and that the rules are available to the public.
Minister, make it stay in the Gazette. We deal with it
Why you relent?
as we go along. Make it stay.
Ask him why he's relenting.
Member, could you say why you are relenting?
Yes. Well, you see, the Gazette is, everybody, I suppose, know about it. The council just have to find a way to get it published. It is probably the most efficient way, and so on. And the lawyers who are in the news will get a little work.
Thank you, Member.
Can I just share, just say that our reluctance to have things published in the Gazette are because of well-known challenges in getting things published in the Gazette in a timely manner. but perhaps these are issues that may be resolved, and so that should not be the reason that we decide not to use the Gazette. Because if one day we become very efficient at it, then, you know, why not use the Gazette?
All right, thank you, SG. Member Graham, I have not found an issue with gazetting things.
And it may well be improving. It's just that you have to bear in mind that you have to do it, because a lot of agencies who are required to gazette never do. And there's a lot of argument whether it is unlawful if you don't have it in the Gazette and all of that. So, but it would be, there you have it, let it stay. It's just something that they have to do.
All right, Council?
The other clause that was inserted is in relation to protection of members. That clause would read as paragraph 14. 14.1, no action, suit, prosecution, or other proceedings shall be brought or instituted personally against any member of the committee in respect of any act done bona fide in pursuance or execution or intended execution of the committee's functions under this act or any other enactment. 2, where any member of the committee is exempt from liability by reason only of the provisions of this paragraph, the council shall be liable to the extent that it would be if that member was an employee or agent of the council. (14.2), reread. No action, suit, prosecution, or other proceedings shall be brought or instituted personally against any member of the committee in respect of any act done bona fide in pursuance or execution or intended execution of the committee's functions under this act or any other enactment. 2,
that is speaking now to the members of the PPCC. So go to 2 now. No,
where any member of the committee is exempt from liability by reason only of the provisions of this paragraph, the council shall be liable to the extent that it would be if that member were an employee or agent of the council.
The use of the term employee is in connection to what? An employee of the council? Who are we trying to protect? In 1, you're trying to protect the member of the committee. In 2, who are you trying to protect?
No, in 2, it's the member.
The PPCC members. How about the fault? In accordance with.
If they're exempt from liability.
If they're not exempt as it relates to A, then the liability would pass to the council.
That's not how I understand.
That's how I see it. So it's like vicarious liability. Yes.
But what I'm hearing, is if you are protected under 1, because you're the member.
Right.
Right. If the member is protected, you can't go against them personally.
Right.
So, but it don't stop you from going against the council for the misdeed of the same member. That's how I understand it.
I'm trying to understand now, because I hear what you're saying and I agree with what you're saying, because it's a question of passing on that liability. But difficult for me to hear it sometimes and not reading it and seeing it. But the use of the term now, employee, just that part again, I want some clarity on.
Employee situation. What it is saying, you are being treated for the purpose of liability of the council as if you were an employee. So if you are an employee in the regular situation, let's say you're driving my minibus, yes, and you're getting an accident, you're my employee, I'm going to be responsible for you vicariously. So I think that I understand them to say you're going to be viewed as if you are an employee, and if an employee would have made you, the council, liable in this situation, then the council is liable.
But the use of the term employee is a specific term. I think it may be defined in law somewhere, if I'm not mistaken. So we can't just use the term employee generally here, because they wouldn't be employees. They are more agents. I think that there's a difference between the term employee and the term agent. And I think there are more agents. So we'd have to go and define that, the term employee. But we already have an appreciation of what an employee is. And this, I don't think members of the PPCC would be considered employees at all. So but I would prefer as if you were an agent. No. So take out employee, and I would appreciate the term agent. Yeah, but the PPCC members are not employees of the council. They are the people that we identified here, the attorney and the... Can we reword it then? I don't know. I'm having a difficulty.
Is this a standard provision?
Yes, it is a standard provision. And I think we should bear in mind that the council is not only comprised of members, but of course the council employs people. So if there is liability in this case, the council would have to assume the liability as they would if the person were an employee or an agent. I think that is the essence of the provision. Just by saying agent, because we normally include employee. So I suppose we could go back and see generally what other pieces of legislation say and make a determination as to whether we could leave out the word employee.
All right, thank you, Ms. Sherlin. So that would be a matter to be researched as to whether or not we have to say as if an employee. All right, thank you. Ms. Gordon-Jones, does that cover all the matters arising?
Excuse me, Chair.
Go ahead, SG.
Sorry. We're just looking at that provision. I'm a little lost. Is that protection for the PPCC or for the council generally?
Protection for the members of the PPCC.
I'm happy that SG asked that question because we do not have that for the board, and that's something that I was going to raise for the council. There is no provision for protection of members of the council.
From the council itself. Okay.
Okay.
So we were SG, so we were talking about the PPCC,
right,
and whether or not we should be using the term as if they were employees and rather than agents.
Sorry, so I didn't understand the discussion then about employees and agents and so on, because you're just protecting the members of the PPCC. I suspect the provision that is being used, I think, came from Nero, but it's not a. It's not always crafted that way. And so this is why I wanted to understand who are we trying to protect in that specific provision? Is it just the members of the PPCC?
In this provision, council, it was just the members of the PPCC, but legal counsel just highlighted that there needed to be a similar provision for employees of the council, or members of the council or employees of the council. Members of the council.
SG is raising a valid point, because that part B that was included, I don't think is really necessary. That speaks to employee and agent. So part A spoke to not being able to be sued while they're carrying out their duties, the personal liability. We do not have a similar provision for the council, but I think if we leave that Part A for the PPCC and include a similar provision for the council, then we should be fine. Because as long as both entities are acting within, the lawful duties, then the personal liability would obtain. I don't know, SG, if that is what you're trying to ascertain.
All right, SG, I don't know if you were going to come back in for another intervention.
Yeah, no. No, I don't understand the two at all. I don't understand it.
So are you saying it could be merged rather than having two separate?
A servant or agent. Yeah, we would need to just look back at it. I'm sorry, Chair, because I'm just looking at it now, and employee or agent. You see, I don't know where they're going to be. I don't know why we're referring to the council in 2 when we are looking at the PPCC in the first place. So maybe this is part of my confusion. 14.1 is dealing with protection of members of the committee. Right. So why does 14.2 then start to talk about the council?
Right.
Chairman, I think that it is a good thing to protect the individual members when acting bona fide. Yeah. That is to say, members of the PCC and members of council. I think that's a good thing, because otherwise the government will have to provide indemnity insurance for them. So that's one. So I think that we could have the protection for the PCC members and also the council members for performing duties bona fide, both of them. Yeah. I think also, this is the first time I'm seeing it, but I like it, that usually you just have a blanket protection and the citizen has no right. But what this is trying to do is to say, even though the individual may be protected, if the individual does something, whoever that individual is, that he would, without this protection, he could have been sued, then you can kick it upstairs to the council to bear the responsibility for them. That's what I understand what they are trying to achieve. So we can either, I think that at the very least, the council members should be protected as well. And we could protect the council and the PPC members and leave it at that, full stop, which is the usual practice. Or we could also go further now and say, but nevertheless, if the members would have been otherwise liable, but for this act, then you can try to sue the council itself on behalf of everybody. That's what I think
So
they were trying to say.
Does that have to be
for
in the act, though?
It would have to be.
Really?
But at the very least, it should be there to protect the members of each body for working bona fide. As to whether you should also have a right to go back to sue the PCC, I like it, but I don't know if SG likes it or so. But it will be the council, sorry. It's a matter that is quite interesting. I like it. Which is...
Oh, wow, I'm
Thanks.
hearing
If I
interesting,
could-
succinct,
if I
clear,
could, Chair?
perfect.
Oh. Hello? If,
SG, please.
right. So what I don't understand is, yes, we are protecting individual members of
SG,
the
you're quite
committee.
low. I don't know why.
Oh, I'm not sure. Can you hear me better now? I don't know.
A little better, yes.
Okay, I'm not sure why it's sounding low. I'm saying, I understand 14.1. I have no difficulty with 14.1, which is protecting individual members. But then the entity, the PPCC itself, is what I think you are allowing then is for the PPCC to then take responsibility. What I don't understand is, why is it that the council is going to be held liable and not the actual PPCC? That is perhaps my difficulty, because the way it's worded, it's saying that if a member of the committee is exempt from liability, who would be liable would be the council. And I'm trying to understand why the council and why not the PPCC. Doesn't the PPCC take decisions as an entity in and of itself?
Right, but the PPCC is not a corporate entity. It's not a body corporate. It's not.
Just use your mic, since you're not using it. But Chair, I think we're referring to the personal liability of individuals. Now, I appreciate the indemnity. But what B is saying is that if a member should act outside of his or her lawful duty, then based on what it is saying, the council now would be responsible for that person's action. But I don't think the council should be responsible for that person's action. That individual should be.
No.
Yes. They are not acting lawfully, you know.
No, but that's different. If they're not acting lawfully, they are not protected because they would not be acting
Right,
bona
so they should
fide.
be open to suit.
No, but they are, because if you read it,
council,
no. If you read what I recall being said, if they are acting bona fide, they are protected.
Yes, and we agree with that.
And if they are acting bona fide, and you could sue the council as well and get something fine. But if they are not acting bona fide, you can still sue the individual. That's why I understand what they're saying.
You sue the council.
No, that's not the way.
Can you reread it? Because that is what I interpret it to be. Please.
Where any member of the committee is exempt from liability by reason only of the provisions of this paragraph, the council shall be liable to the extent that it would be if that member were an employee or agent of the council.
I think my interpretation was correct. I mean, other lawyers may have a different view, but what I understood from that provision was if a member should act within their law.
Acting bona fide. You can make a mistake and act bona fide. You can be negligent and act bona fide.
If they are not protected in one, that's what it's saying. If the member is not protected in A, but that's the same thing. if you're exempt from A, that's what you said. Meaning you're not protected.
No.
Right. So if you're saying you're not protected under A, the action of the member would now be, the council would be responsible for that member's action. That's what you're saying.
So so what it's saying is, one is saying that no suit or prosecution shall be brought against the person if they acted
within their lawful duties.
And
right.
the fact that they are exempted from acting bona fide and you cannot pursue them, you have to pursue the council.
But they're the decision-making body. So are we saying therefore that? So are we therefore saying that the decision-making body, the PPCC, will now not be open to suits? That any lawsuit that should be brought against the PPCC should now be brought against the council?
Right, because that's where resources are. Remember, the PPCC is only acting on behalf of the council.
That's what I'm seeing now. The PPCC is acting on behalf of, in the interest of, the council. So the protection provision is for the members of the PPCC. And the liability, in case somebody wants to sue for the action, that provision now is placed on the council. That's what I'm understanding. They never made the decision, but the PPCC is being protected in carrying out the duties in the interest of the council. So the council now becomes the big yard in which the exposure lies.
But because otherwise,
what it tells us, is that it is the council that is going to be exposed to any review, to any challenge, because they are acting in the interest of the council.
yes, member. SG, did you want to make an intervention?
I'm not sure of the utility. I cannot find a precedent where it's done this way. If a member of a specific entity is being protected, what you always have is to allow for a means of redress. And so if you can't sue the specific member, you would sue the entity. Here the entity is the PPCC. I think the draft should have said that who is liable is the PPCC. We have it even for tribunals. Tribunals are not body corporate, but you don't go against the individual tribunal member. Who you sue would be the tribunal itself. It's the entity, not the umbrella organization or group. But I don't know, perhaps it can be done that way. And I mean, your law can put in provisions that would have to be applied. I'm just concerned, though, that when this obligation is now being placed on the council, and the council was not involved in the deliberations and discussions and the decision of the PPCC, I think it's a little unfair to place that burden on the council and not place it on the actual entity, which is the PPCC. Just my own view.
Well, could I ask a question, though? Let's say, SG, that there's a judgment against the PPCC in the situation you painted, and it's for $1 billion. The PPCC is not an entity that has such a budget. What would they do in that situation?
So just as what happens with tribunals now, ministries, where the tribunals fall under specific legislation, the ministries cover that. Government covers it. That happens currently. Tribunals, appeal tribunals don't usually really have a budget either.
But
you have
this is
decisions
not
against
not the tribunal though.
No, but
There's a
I'm
separate
making,
tribunal. This is
yes,
it.
and I'm making a parallel.
Okay.
Because you could easily have this provision apply to the tribunal where you don't hold individual members, and you should actually have it because it's in any other law that you look at. You should not be able to hold individual members of a tribunal personally liable for actions that they took which were not anaphoric and which were not negligent and which were carried out as part of their functions as a member of the tribunal. Normally, what the law usually provides for is that the tribunal itself would be held liable, and when there are decisions against the tribunal, those costs, including even when they're successful, if there may be costs for counsel, not just a judgment that's against them, but those costs are usually borne by the responsible ministry. That happens now.
I think I see two separate situations. If it is that you have a matter before the PCC, and let's say it rules against you, and you wish to challenge that decision, the challenge, of course, will be against the PCC, against the decision. An appeal, it will be allowed or not allowed, etc. But the way I understood the draft from what was read is a separate situation where you want to sue the member because the member has done something that has caused you loss. Not something that they have made a decision, but something that, so you're not challenging the decision, but let's say the member defamed you then, said something else outside that was defamatory, for example, and you wish to bring a suit to recover damages. My understanding is that you could not sue them because they were negligent in the way they conducted their thing. So long as they're acting bona fide, you could not sue them personally.
But they wouldn't be acting bona fide then.
Well, you can be negligent and still acting bona fide, but we won't argue about that today. But it is possible. But the question then that comes now, if you are suing them for something else apart from the decision they make, you can't sue them on the basis of what was just read, but you could sue their principal, who would have been the council. I understand what the SG says, that of course the council may not know what was happening and so on, and that's a point. So it's a matter as to whether we keep the provision or we simply just have number one and leave it at that. It may well be that you will avoid all confusion and leave it at that, because even without number two, you might still be able to sue everybody anyhow under general law. So it possibly, you could probably leave it out and still be okay. You okay? Okay. Oh.
All right. So, Council, if you could just summarize as to where we are and what we need to vote on, that would be great.
So based on the discussion and Member Braham's last comment, it's whether we will retain 14.1 and do away with 14.2.
So just reread
provision
14.1 again,
for
and
14.1.
then we'll vote on it.
No action, suit, prosecution, or other proceedings shall be brought or instituted personally against any member of the committee in respect of any act done bona fide in pursuance or execution or intended execution of the committee's functions under this act or any other enactment.
Before you, okay, they're not leaving. They're not leaving. So we'll continue discussing and ratify at the next meeting. Okay. We'll continue the discussion. All right. So we'll take 14.1 as read until the next meeting. All right, so members, when the new draft is circulated, at the next meeting we will accept the new amendments or reject. We will review and make a determination. And all the other paragraphs that were read.
For the other paragraphs that were read, I think we can make a determination now, because I think we were okay with everything up to this point. We do have a... we can do it at the next meeting then. That's fine. So we can just continue with the discussion and that's fine.
Okay, please continue.
In terms of the protection of members, we're proposing for consideration at the next meeting a similar provision for the council. And also, it was noted that there is no provision for the council in relation to the filling of vacancies. So the proposal for the next meeting is for a similar provision as for the PBCJ be inserted. Yes, that's a succinct one that you loved. Another for consideration is in relation to the revocation of appointment under the council. we are proposing that we adopt for consistency a similar provision as is agreed for the PPCC. In terms of A, which mentioned the Mental Health Act, and B, which only spoke about the Insolvency Act and not compounds with or suspends payment. Those two changes. In relation to remuneration, Chair, I'm not sure if the intention is to also mention salaries for the council. I remember the last discussion was no salary. I'm not sure if it's applicable to the council as well. Right, for the PPCC, we said no salaries. So is it applicable for the council as well? So
wouldn't they get the regular stipend of other government? Yeah, stipend.
It really wouldn't be fair for the council to not get a salary and the PPCC to get a salary. So it has to be uniformed. It's a stipend.
Okay, so we will
Agreed.
consider for removal of the term salary in that paragraph. In terms of disclosure of interest, Chair, it indicates the matter of notice, but based on the previous discussion we did, it did not indicate whether it's in person or in writing. Disclosure, I'm at Part A, clause, paragraph 12, disclosure of interest. That's for the council. For the council. So we're thinking it's not read. It's not read similar to the provision that we indicated. If you look at it now, paragraph 12 under Part A. First schedule, Part A, paragraph 12, disclosure of interest. I don't think so. The document that starts with 51. Page 17. So it speaks to the matter of disclosure, but it does not indicate that it's either in person or in writing. So just for consistency, I was proposing whether we could insert after the fourth sentence said, shall disclose or cause to be disclosed either in person or notice in writing. Something similar to what we did for the PPCC.
I have a preference for disclosures such as this to be in writing. The in-person, while yes, it should be captured by minutes, things happen. So I would rather something in black and white for both PPCC and council.
Agreed, member.
So we are not to say in person. So what if the disclosure was underground? It can be followed up, so you will allow for in-person disclosure, but it should be.
You see, Chair, you're in this meeting now, and you identify a particular conflict of interest. And so you want to, in the first instance, have the opportunity to declare on the spot. But as a follow-up, you confirm that declaration in writing. Because the first thing you want to do, you want to be able to cease any other involvement at the time. So you identify the conflict and you declare it. Follow up in writing for the confirmation.
Agreed, member, because I'm sure there have been situations where a person says, I declared it at the meeting, there's nothing in the minutes. We don't want to get into that. Yeah. Continue, Council.
Just to query if we should include a time frame within which that notice in writing should be followed up or not.
The answer to that is yes. What you want to do is to compel the person to put it in writing, and for those to receive it, creating the expectation or anticipation that it shall be received within a defined period. This is an area that we really have to tighten up on in governance.
What would that time frame be? By the next meeting?
It really can't be the next meeting. Because the next meeting might be discussing the matter. So you want to have a time frame to, I would say 5 days, 3 to 5 days.
3 to 5 days.
Long to make that declaration in writing.
3 to 5 days.
Because they could do the declaration after the end of the meeting, they could write it. Chair, the other thing for consideration for the next meeting is as a result of the change from the term board to council based on our perusal of the bill. Clause 7 of the bill treats with the functions of the council, and clause 13 speaks to the functions of the board. And as a result of that, it would need to be revisited to be properly phrased as to have the functions
So
in one.
what would it be called?
It would be the functions of the council.
Right, but what is the board of the council called?
Yes.
So it's the council of the council?
It's the council.
It says here, the board shall be the governing body of the council. But you're really talking about the council being the governing body. No, not of the council, not of.
It would be the governing body of the Jamaica Teaching Council. So you're saying the council would be the governing body of the Jamaica Teaching Council?
Right. The council shall be the governing body of the Jamaica Teaching Council.
Remember that is the name of the entity. And
yes.
I guess because it ends with council, that's the
Yes, that's the little
So why we can't use board?
I'm just thinking of
The
that.
board
but,
of the council. What's wrong with that?
The board of the Jamaica Teaching Council.
To not confuse it with the PPCC.
No, the PPCC is a committee.
That's right,
Yeah.
a committee.
Confusion with the PPCC, Chair, because that's just a committee of the council. But I think based on the discussions and deliberations we've had to date, we've been referring to the council, meaning board, or the term that we would normally use as board. The only difficulty, as you know, you mentioned earlier, is the fact that the Jamaica Teaching Council has council in it. But we've been referring to the council. And I don't know if the Jamaica Teaching Council's functions would be different from the council's function. It's the same.
Remember, the council is a board.
Right, but the functions would be the same, regardless of whether or not it's the board or the council. It's one entity. So reference to the council would be reference to the council, I think.
All right, I yield.
So, Chair, as a result of that, we'll have to re-examine and make the necessary amendments.
And you'd have to treat it under part 1, the definitions now of board and council.
Right.
Just to ensure that they are in alignment.
No, we'd have to remove one.
Remove one.
Yes. We have to.
Excuse me, Chair, Madam Chair.
I'm sure. Go ahead, SG.
Thank you. I'm not clear on what the decision was. Was the committee revisiting the issue of the use of board as opposed to council?
I think at some place in the bill, there's a reference to board, right, Ms. Gordon-Jones?
No, and
And
that's
that-
correct, Chair, but in the minutes of the last meeting, if I could read page 7, and it's in bold, the committee accepted the suggestion to delete the term board and its reference in the legislation, which would be replaced with the terminology council. So I just wanted to know if, having regard to that decision taken at the last meeting, what's the new decision?
There is no new decision. I think
Oh,
I think Mrs. Gordon-Jones was just trying to get clarification or confirmation, but I believe, just confirmed that we are referring to council and not board. That's not it? Oh.
I just wanted to point out to the committee that based on the change and the provisions in the bill currently, Clause 7 speaks to the functions of the council. Clause 13 speaks to the functions of the board, because we were using both terms. And so, as a result of that, we're going to have to examine both functions based on the change to see the functions that are there, which functions we would now indicate as the functions for the council, and if it is that there is any possibility that some of the functions have to be carried out by the CEO.
The functions are different. 13, so 7 is the operational, administrative, everyday carrying out, as demonstrated by the council. 13 is more of a governance. Really like a board. So you really have to look at them. Yeah. So 7 is day-to-day operations. 13 is more overarching.
All right, so where are we? That's it? All right, for those amendments, next meeting we'll start on we'll do this, we'll confirm. So if we could get a draft circulated with all the amendments so that we can confirm them at the next meeting. But also hopefully we'll get on to the second schedule, right? And any other items that are outstanding. So Ms. Gordon-Jones, could you just list for us the items that are still outstanding? No, I know the items from this meeting.
Something that was, there was a document that was circulated that indicated the outstanding items that we have noted based on the previous meetings. It's a document that says Jamaica Teaching Council bills some items for finalization to be taken by the Joint Select Committee.
So can you update that one? Or those are still all the same items?
Well, none of those items have been touched. None of those, no. It was not settled. It was not.
All right, for the next meeting, we will take these items arising from the minutes this week, right? All these items, and also this document entitled Jamaica Teaching Council Bill, some items for finalization to be taken by the committee. Right, includes that. And the schedule 2, right? Or schedule 2. All right. So just for the record, council, just go down again for the next meeting. If you could just say what it is that we need to have considered for the next meeting. Just say the items, we'd have the items from today that you will indicate, right, for confirmation at the next meeting, but we also have this document that you reference, and then we have the offenses, that one, right, and
Offenses. So the document that includes the outstanding items includes the list of offenses.
Okay. And
those,
the schedule. The schedule is in there as
second
well.
schedule.
Second schedule. All right. Good. Thank you so much. The next meeting is scheduled for October 4th, 5th, sorry, Thursday, October 5, yes. We need our members to still be fresh so we can just finish off. If we go too long, then we get back and we're repeating things. So let's just, afternoon, 2 p.m., 2 p.m. So let us come back while we're still fresh and knock out these items so that we can get a totally clean bill to move it to, well, we need a report as well. Yes. All right, so Thursday, October 5, starting at 2 p.m. And then we will also send notice for a subsequent meeting. Yes, we will send out a notice. Thank you. All right, thank you, members. Thank you to the technical team. Thank you so much, those who are here in person, those who are online. Thank you, members. Thank you, members.
Something is happening for someone in this country every single day as a result of the actions of this government. The beneficiary of this house and the hundreds of people who have benefited so far, they feel good and their families feel good.
Oh, I'm on top of the world. It's just a dream come true. Somebody